This statistic shows the share of adults in the United States who identify as lesbian, gay, bisexual, or straight in 2013. In 2013, 1.5% of American adult women identify as lesbian, while 1.8% of American adult men identify as gay. The number of states allowing same-sex marriage has grown rapidly. As recently as October, just over one-third of the states permitted same-sex marriage. Now, same-sex couples can marry in 36 states and the District of Columbia.
The Supreme Court is currently hearing pivotal cases on the issue of gay marriage, deciding whether the Equal Protection Clause holds true for gay marriage. If the court decides gay marriage shouldn't be federally legal, then marriage will be defined biblically between man and woman, and there will only be a traditional lifestyle of father and mother. However, if it decides to uphold gay rights, then there will be a conflict with the certain religions that ban it. Marriage will become modernized and redefined, making all marriage equal. The United States will have to deal with these implications, which will be far-reaching.
The Equal Protection Clause is part of the 14th Amendment. The clause prohibits states from denying any person protection of their equal rights. In other words, the laws of a state must treat an individual in the same manner as others in similar conditions and circumstances. If this is what the Constitution says, states should not be able to prohibit gay marriage because the state is denying their equal rights of marriage based on their sexuality.
In the 1920s, gay marriage became an issue. There was a ban made on gay workers and they were fired. They also closed gay bars because of the Cold War and for the desire to present America as a wholesome, for being gay did not fit into the American dream. During the civil rights movement in the 60s, people started to fight for the rights of marriage. There was a Supreme Court case held, Loving v. Virginia, in 1967 on interracial marriage. 17-year-old Mildred Jeter, who was black, and 23-year-old Richard Loving, who was white, got married in Washington, D.C. They returned to their hometown and got sent to jail for unlawful cohabitation. Judge Leon M. Bazile stated, Almighty God created the race white, black, yellow, Malay, and red, and he placed them on separate continents. The fact that he separated the races shows that he did not intend for the races to mix. The Lovings were either sentenced to a year in jail or exiled from the state for 25 years. When they came back to visit, they were arrested for traveling together. Mildred decided to write a letter to Attorney General Robert F. Kennedy to help her fight this case in court. The ACLU represented them in the Supreme Court case. The final verdict was that state ban on interracial marriage is unconstitutional. Ava Alterman, a retired New York City judge, came of age just at the same time as the burgeoning of the gay rights movement.
What was it like growing up when knowing that you weren't allowed to be married?
I would say stressful mostly. I mean, I grew up in a time when it really wasn't even acceptable to be gay. So I, was forced really to have a whole secret life and secret parts of my life separate from the rest of my life. And whatever was going on, whether it was good or bad or anything joyous or anything sad, I couldn't share it with other people in my life. And that was really, I think, stress probably would sum that up. And confusion because I didn't see anybody else out there in the world that I thought I was a part of that looked like me. That was like high school age. I guess by the time that I got to college and law school, I started to realize that there were all kinds of things out there that would be, although I was okay with who I was and what I was, that the rest of the world was not, and that although I didn't really care about their opinion of me, I didn't really need their approval, there were going to be all kinds of legal things, technical things that I was not going to be able to have access to. I didn't have certain rights that every other adult would have. I didn't have protections that other people would have, whether it was, employment discrimination or, again, being able to be married to somebody who I loved or having protections for whatever kind of family I wanted to form or my kids or my whoever else's kids that I was living with, and even the fact that I couldn't even have a term to apply to. What's like a girlfriend, a lover, a partner is too businessy. That, someone who I was willing to make a commitment to in terms of love and finances and all these other things, there wasn't even a word to describe it. So, being a second-class citizen, how do you even begin to describe?
Laura Frank is a history teacher at SAR High School and is getting her doctorate in Jewish history with a focus in marriage. We asked her if she could share with us the history of gay marriage.
Gay marriage was not really on the agenda of the gay rights community until the AIDS crisis in the 1980s. As gays and lesbians saw what happened when gay men were dying of AIDS, and we're not able to have their partners act as healthcare proxies for them. We're not able to have their partners inherit their estates or their assets. We're not able to have their partners make healthcare decisions in any way for them, have survivor benefits, any of those kinds of things. They realized that marriage was something that they needed in order to give them the legal rights that marriage comes along with in the United States. At the same time, as reproductive technologies started to develop and get more and more advanced, lesbian couples started to have babies where using sperm donors, and the same thing started to happen with them regarding legal rights, meaning a lesbian woman might give birth to a baby, but her partner had no parental rights for that child unless there was some kind of a relationship between the mother of the baby and her lesbian partner. So because of sort of what was going on medically in the United States at the time, gay marriage began to become a much more powerful item on the agenda of the gay rights community. And going forward, that's the direction that they started to move in as they sought rights for themselves.
There are 4 cases that went to the Supreme Court dealing with the issue of gay marriage federally. The overall issues are these 2 questions. 1. Does the 14th Amendment require a state to license a marriage between 2 people of the same sex? 2. Does the 14th Amendment require a state to recognize a marriage between 2 people of the same sex when their marriage was lawfully licensed and performed out of state?
The first case is Obergefell v. Hodges. Jim Obergefell was married to John Arthur in Maryland, but they lived in Ohio. Arthur was dying from ALS, and Obergefell wanted to be his surviving spouse on the death certificate.
The second, Tanko v. Haslam, is a lawsuit on behalf of 3 legally married same-sex couples challenging Tennessee laws that prevent the state from respecting their marriages and treating them the same as all other legally married couples in Tennessee. The third is DeBoer v. Snyder. April DeBoer and Jane Rose are challenging Michigan's same-sex marriage ban so that they may better protect their family and adopt each other's children.
And the fourth, Bork v. Bashir, 4 same-sex couples argue that the anti-marriage laws violate due process and equal protection provisions of the U.S. Constitution.
Different religions believe in different things. Because gay marriage is an issue among religions, it creates an ambiance of discrimination towards homosexuals. If gay marriage becomes legal, certain religions will have to figure out how to deal with gay couples in their community. If the court decides against gay marriage, certain gay couples will feel discriminated against and become less religious.
Russell Moore, president of the Ethics and Religious Liberty Commission of Southern Baptist Convention, says that evangelicals base their beliefs around the Bible, and therefore, and no matter what the Supreme Court says, they will not allow the same-sex marriage because the Bible explicitly defines marriage. Anyone who supports gay is not an evangelical.
Ryan Anderson, a fellow at the Heritage Foundation who co-authored What is Marriage with Princeton scholar Robert P. George, is a Roman Catholic. He says that depending on the way LGBTs react is the way the conservatives will react. If there is respect, then the conservatives won't push back as much.
Rabbi Tilly Hartstock is the principal of the Modern Orthodox High School SAR. We asked him to share with us SAR's policy on gay marriage. In Judaism, it is forbidden for man to lay with man. Depending on what side one falls on the spectrum of observance, this Jewish law is understood differently.
I feel like it is, first of all, I think the Torah prohibition is specifically against homosexual acts. While the Torah doesn't have a category of gay marriage, it's something as a category, I think it's outside the realm of halacha. The Torah doesn't have anything to say about someone being homosexual, and it doesn't have something to say about what they are determining as marriage. So I would feel absolutely responsible to respect the law as they decided on it in this instance, because I don't think that there's a direct conflict with, doesn't engender a halakhic violation.
With the evolution of modern times, ideas change and the way people act adjust. If the court decides to federally legalize gay marriage, there will be a conflict with people that believe in traditional marriage. If gay marriage isn't approved, then marriage won't be modernized and homosexual couples will still have conflicts and problems maritally.
According to PBS, a ruling that same-sex couples have a right to marry would invalidate the remaining anti-gay marriage laws in the country. If the court limits its ruling to requiring states to recognize same-sex unions, couples in states without same-sex marriage presumably could get married elsewhere and then demand recognition at home. The bans in 14 states would survive. Beyond that, confusion would probably reign. Some states that had their marriage laws struck down by federal courts might seek to rescind prohibitions on gay and lesbian unions. Questions also could be raised about the validity of some same-sex weddings. Many of these problems would be the Supreme Court's own making. The Supreme Court had the hearing for these 4 cases on April 28, 2015. The decision will be made this June. Not only will the decision shape the future, make an impact on the rest of the world, and is history in the making, it also shows that the world is changing and the fight for equal rights among all will continue.